Did you know that you can immediately destroy your case value depending on what you say or not say when the insurance company calls you? In this video, I'll reveal 4 critical rules that protect your case and maximize your settlement. Hi, I'm attorney Fran Hosh. I've helped over 10,000 bikers and crash victims here in Florida. That's why on this channel, I show you how insurance companies really work and what to do to get every dollar you deserve. To start, let me show you the first rule that can either protect your case or destroy it in one innocent mistake. Insurance companies will call you within hours of your crash. They'll sound friendly, caring, and helpful. They'll say that they just need a quick recorded statement to get the process started. This is the biggest trap they'll set, and most riders fall right into it. Let's go for a hypothetical scenario. Let's say you're in pain, overwhelmed, and the insurance adjuster calls, sounding so nice and concerned. They ask innocent questions like,
How fast were you going?
"You estimate
Maybe 25 miles per hour?
Later, the police report shows the speed limit was 35. Now, the insurance company claims you were driving erratically slow and caused the accident. They ask, "Were you wearing a helmet?" You say, "I think so, but I was pretty shaken up." Now, they argue you can't remember basic facts, so your version of the accident isn't reliable. Every answer becomes ammunition against you. The key point is that insurance adjusters are trained to sound friendly while collecting information to deny your claim. They're not your friends helping you. They're building a defense against paying you. Even innocent, truthful answers can be twisted into weapons against your case. So how do you protect yourself? When the at-fault driver's insurance company calls, say these exact words: "I'm still recovering from my injuries, and I'm not ready to give any statements right now. Please send me your information in writing." Then hang up. Don't explain. Don't justify. Don't give them anything to work with. You have no legal duty to give them a recorded statement ever. But even if you avoid recorded statements, this next rule can save you from accidentally giving them information that destroys your case. Insurance adjusters are experts at getting information from you without formally recording the call. They'll call and say,
This isn't a recorded statement. I just need to understand what happened.
then they'll take detailed notes that become part of your file forever. Here's what happened when one rider didn't understand this difference. The adjuster called and said it was just an informal chat. The rider mentioned his back was sore, but not too bad. 6 months later, when his back problems got worse and he needed surgery, the insurance company said,
But you told us your back wasn't too bad. Now you're claiming you need surgery? This sounds like fraud.
the informal conversation became a formal evidence against him. What that teaches us is every conversation with the at-fault driver's insurance company is being documented. They're building a file to minimize your claim. There's no such thing as a casual chat or off-the-record conversation. Here's exactly what information is safe to share and what's dangerous. Safe information: your name, the date and location of the accident, and that you were injured. That's it. Dangerous information: how do you feel, what hurts, how the accident happened, your speed, weather conditions, what you were doing before the crash, whether you were wearing gear. All of this can be used against you later. Now, even if you limit conversations perfectly, there's one document that can give them access to destroy your entire case. Insurance companies love to rush into signing medical releases. They'll make it sound routine and necessary. They'll say, "We just need to verify your injuries," or "This helps us process your claim faster." This is a trap that gives them ammunition to attack your case. Let me show you how dangerous this really is. For example, you sign a medical release thinking it's no big deal. The insurance company discovers that you were treated for back pain 5 years ago. Now they claim your current back injury isn't from the motorcycle crash. It's just your old back problems flaring up. They'll argue they owe you nothing for an injury that existed before the accident. Or maybe you were treated for depression 10 years ago. Now they'll claim your current pain and suffering isn't from your crash. You were already depressed. They'll use your own medical history to minimize every aspect of your claim. The important thing to understand is that medical releases give insurance companies access to your entire medical history going back years. They're not just verifying your current injuries, they're hunting for any reason to deny your claim. Once you sign, you can't take it back. So how do you handle medical release requests? Never sign anything without a lawyer reviewing it first. When they pressure you, say, "I need to have my attorney review the documents before I sign them." If they say they can't process your claim without it, that's not true. They're trying to pressure you into giving up your rights. But here's where many riders make a critical mistake that can hurt their case, even when they follow the first 3 rules perfectly. Many riders don't understand there's a huge difference between dealing with their own insurance company versus the at-fault driver's insurance company. This confusion can destroy an otherwise good case. Here's what happens when you don't understand the difference. You properly refuse to give a recorded statement to the at-fault driver's insurance company. Good move. But then your own motorcycle insurance company calls about your uninsured motorist coverage. You refuse to cooperate with them too. Now you violated your own policy terms. Your own insurance company can deny your claim for not cooperating. You end up losing money that should have been yours because you treated your own insurance company like the enemy. What this shows us is that you have different legal duties to different insurance companies. You must cooperate with your own insurance company. That's part of your contract with them. But you have no duty to help the at-fault driver's insurance company build a case against you. Here's your step-by-step guide for handling insurance calls. First, always ask, which insurance company are you calling from? If it's the at-fault drivers, limit conversations and don't give statements. If it's your own insurance company, you must cooperate with them, but you can still have a lawyer help you. Second, for your own insurance company, give truthful information. But don't speculate or guess. Stick to the facts you know for certain. Third, even with your own insurance, avoid detailed recorded statements about fault or how the accident happened until you talk to a lawyer. Fourth, never sign medical releases for the at-fault driver's insurance company, period. Here's what happens when you follow these 4 rules correctly. You protect yourself from having your own words twisted against you. You prevent insurance companies from using your medical history as a weapon. You maintain your rights while you're still meeting your legal obligations. Most importantly, you keep control of your case instead of accidentally giving it away. If you're a motorcycle rider who's been injured in Florida and you want to make sure you're protecting your case properly, call me at 866-LAW-FRAN for a free case consultation. I'll use my medical background and 25 years of trial experience to guide you through every conversation and make sure you don't accidentally hurt your case. And if you want to learn about the #1 mistake that stops motorcycle accident victims from getting paid, a mistake that happens even when they follow all these rules, watch this next video where I reveal the biggest case killer that most riders never see coming.